There was an order by your sister, the Honorable Lady Justice Henry Ongudi, which was made on the 8th of November, 2022, which stayed the disciplinary proceedings at the time. Yes, Your Lordship. And Your Lordship, should you have an examination of that suspension letter, you note that the same concerns the very same units to which your judgment relates. That being the case, Your Lordship, we'll be humbly seeking the court's indulgence to enable the respondent to engage the petitioner to exhaustively address the issue of the suspension, which is still in force and which has not been set aside in this decision that the professor is subject to. Your Lordship, subject to the concurrence of the petitioner's counsel, the respondent is more than happy to take timelines as to be supervised by the court for purposes of achieving the desired compliance with the decision of the court. Your Lordship, finally, as explained by the professor and given that contempt proceedings also concern an 11 humble plea that to best achieve the desired outcome, the respondent be given an opportunity to take the necessary steps as supervised by this court to remedy and comply with the terms of the judgment. The circumstances, Your Lordship, we will be praying that the respondent be given such opportunity and that these proceedings be deferred to a future date. However, in the intervening period, the necessary steps be taken to comply with the orders of the court. We are most obliged, Your Lordship, and we are guided on the way forward. Thank you.
When we started these proceedings, the court addressed the contemner and told him that he's here as a contemner and that he has already been found guilty of contempt, and that he's here to explain why they have refused to comply. Your Lordship, the contemner has responded by saying that they are keen on resolving these matters. And he has also said that he is aware of the judgment. Your Lordship, my position is that their conduct does not demonstrate their keenness to comply. And the records will show that on the question of the application for contempt alone, the court indulged them at least 4 times to file responses to that application. And at the very end, they did not file anything. Your Lordship, that conduct does not demonstrate commitment to comply. They're not saying that they were not aware of the contempt proceedings. And your Lordship, to also now come and start saying that there are questions as to suspension. Your Lordship, those are matters which were in the petition and which they had a chance to respond to, and which they chose to file grounds of opposition and no replying affidavit. Your Lordship, if we are to go into those issues, we'll go back to relitigate the petition. Because the question of suspension, for example, in the petitioner's position is that he was suspended after he filed the petition as a way to twist him. So, Your Lordship, what I'm saying is that if we go into those matters, we'll go back, we'll be reopening the case. And that if my colleagues wanted to reopen the case, they should have appealed the judgment. So really my expectation today, Your Lordship, was that they would come and tell us that these are his marks, or to come and tell us that here is what he should do. And that has not been done. I appreciate that he has sought for time. Your Lordship, if the court will allow them time, we pray that it be a limited time, considering that this petitioner has not graduated since 2022. His friends have left him, basically. His friends are working, him is not working. So that is all, Your Lordship.
For the petitioner, the respondent at this point, the respondent cannot at this point raise issues of fact that were not canvassed at the trial of the petition as an impediment to full compliance with the orders of this court. That would be inviting the court to litigate the case, which this court is not prepared to do, as it is now functus officium. However, having listened to the contemner, I note that he has demonstrated his willingness to comply with the orders of this court, and it's only fair that he be given an opportunity to do so. The orders of this court that require compliance are clear, as very well cited by him, and thus grant him a period of 30 days during which he is expected to put in place measures to ensure full compliance. In the event of default or failure, this court shall revive and undertake the process of punishment. This matter shall now be mentioned when